So, dear colleagues and friends from the AIIC Legal Interpreting Committee, I don't know if you know me, so that I will have to introduce myself. I'm Christiane Driesen. I am the convener of this committee. And on behalf of all committee members, I welcome you to our 4th Zoom conference. This time, we will be focusing on the work of interpreters at the International Court, Criminal Court, and it will be presented by our dear, I don't want to say old colleagues, Andrew Constable. We have known each other for many years and been on 2 projects together, and Alfred Goma-Bayou. And I have been delighted to come to know him, and I'm glad to hear and what he's to be hearing what he will have to tell us from this experience as an interpreter from rare languages. As an association of interpreters, we rely on multilingualism and are grateful to have 2 dedicated colleagues interpreting this session into English. We have Camille Collard and Chris Guichaud de Fortis, and they deserve our big thanks for their assistance and for giving me the possibility to proceed in my mother tongue and to demonstrate how multilingual we are. So if you want to listen to the interpretation, you have to click on the globe underneath and to switch to the English channel. It's the first test, because afterwards, when Alfred will be speaking, you can listen it on the English channel. So I hope you managed and you found it. Et maintenant,
so now, if I make so bold, I shall briefly present the Legal Interpreting Committee of AIIC. Our mission consists of contributing to protecting rights in an equitable trial setting. And what we do is to offer a form of exchange for interpreters from national jurisdictions and international jurisdictions. Our committee, which is the AIIC, Legal Interpreting Committee, cooperates with a series of professional associations and organizes a number of events, such as training seminars and information seminars. And these meetings traditionally were always held in person. And we've had seminars and conferences in Paris and in London to enable people to discover the various legal procedures in the countries concerned. And we've also met in Luxembourg to discover the Luxembourg Court of Justice, and also in Germany to enable people to understand the workings of other courts for the first millennium. We also had a seminar in San Francisco, which was excellent, at the same time as the Nuremberg exhibition was put on. And in response to the pandemic, obviously we had to adapt our approach. And we then organized a series of presentations through Zoom. The latest event which we were able to put on, just to quote an example, was Dr. Saavedra, who presented the Inter-American Court of Human Rights, and Dr. Karen Jednek, who is a doctor in prisons in the USA, in the prison system. And our last seminar covered a very important institution for interpreters going forward, which is the new European Parquet, the prosecution office represented by the European Judge Perillo. Now, if I make so bold, I will introduce you to or present the active members. Veronica Perez Guarnieri, who you will have seen, and is normally in Buenos Aires. But currently, I think I'm right in saying that she's in Malta. Then we have George Drummond, who is our faithful Scotsman from Hamburg. And last but not least, the organizer of today's conference, who has worked night and day, wearing her fingers to the bone to set up this event. Katerina Apostolaki from Greece. I think she's in Athens now. Katerina, you have the floor now to introduce our two speakers and maybe guide us as regards the way in which the event will go ahead. Thank you to everybody for being here.
Well, thank you, Christian. It is a pleasure to welcome you all here today. Just a brief reminder that the event is being recorded, so please keep in mind that anything you say will remain on the record. So AIIC's Legal Interpreting Committee is joining forces today with SYDISE's Legal Interpreting Committee. So for those of you who don't know SYDISE, it is the Greek Association of Conference Interpretations. And what have we done? In order to facilitate clients who need conference interpreters for arbitrations and other legal work, we have created a special registry with those interpreters who attended CPD on interpreting in legal settings. And that is something that we did in our seminars together with Maria Petrochilou, whom I'd like to thank. And we are continuing to do that now with the president in office, Katerina Chrysantopoulou. So thank you both. Of course, I think that you're all here to hear about the AIIC, which is one of the more broadly known courts that uses simultaneous interpretation. And I, as well as you, will be greatly interested in hearing our two colleagues and what they have to say about working in this very demanding setting. So I'd like to start off by thanking Andrew for agreeing to be our keynote speaker. Andrew is a valued and extremely active member of AIIC, who has contributed greatly to many scientific issues related to interpreting practice, with a special emphasis on distance interpreting, as informed by his work at the AIIC, and he is currently the coordinator of the Task Force on Distance Interpreting, one of his numerous positions in the association. I read with great interest in his short bio that he followed postgraduate studies in EU law, criminal law, and interpreting training, and his work on effective communication in multilingual judicial proceedings, quite the mouthful, I must admit, has just been published in the legal manual, Victim Advocacy Before the International Criminal Court. Over to you, Andrew.
Well, first of all, can I just say what an honor it is for me to be here, to be invited here. I'm now looking at the number of participants, which has gone up to 121. I was expecting about 50 or something, because I've never done one of these things for the legal committee before, but obviously you're able to raise huge numbers. So I think that's a testimony to the very hard work that's been done in this regard. I think in terms of my remarks, what I'll be saying, I'll say a few general things about the court, and then I'll go really more into the specifics of what it's like working as a simultaneous interpreter in international criminal proceedings, as opposed to being a conference interpreter, which a lot of you are very familiar with. So it's like, what is the difference, and how does it affect the way you interpret? Because one of my arguments will be that we have to interpret slightly differently to the way you might be used to in conference settings. I'll also be saying that the expectations of the interpreting, and in particular any transcription that's made thereof, are also quite different. And then I'll make some more general points about my experience of working at the court. As said, I have written this paper. I'll for the sake of the interpreters, also I'm mentioning that I will quote some parts of it, not lengthy bits, but just so that you know, I'll be following that structure for the talk. So without any further ado, I'd like to tell you a bit about the International Criminal Court itself, but let's start by focusing on the language regime and on the linguistic responsibilities that we have at the International Criminal Court. So the territorial jurisdiction of the ICC, the International Criminal Court, has resulted in investigations in a large number of geographical areas in which the languages spoken are as numerous as they are diverse, giving the ICC a language regime unlike any other international organizations. Now, how do we guarantee the linguistic rights of the accused? Well, they're set out in Article 67 of the Rome Statute, namely, to be informed promptly and in detail of the nature, cause, and content of the charge in a language which the accused fully understands and speaks. And furthermore, to have, free of any cost, the assistance of a competent interpreter and such translations as are necessary to meet the requirements of fairness, if any of the proceedings or of documents presented to the court are not in a language which the accused fully understands and speaks. Now, this has sometimes been quite a challenge because we've had even languages where, for example, then it's not a written language at all if we take a Zagawa. So how do you ensure that the that the accused has access, for example, to the witness statements when those statements are in written form, for example, maybe in Arabic or in English, but that person is a Zagawa speaker and Zagawa isn't a written language. So that's something I think is for us as linguists as well, not just interpreters, you might be interested in that. So just to go a bit further in terms of the rules that govern the language aspect of the court, we have the rules of procedure and evidence, and they have Rule 76(1), which provides that the statements of prosecution witnesses shall be made available in original and in a language which the accused fully understands and speaks. And finally, it should be noted that Article 64(2) of the Rome Statute, under that article, it is the trial chamber that is responsible for ensuring that a trial is fair, expeditious, and conducted with full respect for the rights of the accused. Expeditious is an important word here because obviously one of the aspects I'll be coming to is the training of interpreters with situation languages or with languages for which we have no simultaneous interpreters at the moment. And to do that in an expeditious way, as anybody who's been involved in interpreter training knows, is quite a challenge. So just to go on about the trial languages at the ICC. So the working languages of the court, English and French, we have lots of meetings in both of those. Generally, court proceedings are held in both. But we also have these so-called situation languages, i.e. the languages of the accused, and there may be more than one accused in any particular trial, and also the languages spoken by the witnesses called to testify at trial. And you can have hearings held, for example, in up to 4 languages. That's what we've seen so far. In terms of, seems to be, is there a problem with the sound? Okay. In terms of the witnesses coming to testify, we don't, for example, obviously train a specific booth just to do one witness. However, we do train interpreters to provide consecutive interpreting should we not have a booth that's able to do it. So just a bit more about the language services sections before I go on to the next part. The language services section of the registry is tasked with the provision of court translation and interpreting services to meet the court's commitments under the Rome Statute. It provides simultaneous interpreting in the working languages of the court, the official languages of the court, which include Arabic and Spanish, etc., and in the situation languages of the court, which have included languages of lesser diffusion, such as Acholi, Congolese Swahili, Lingala, Sango, and Zagawa. Where no simultaneous interpreters can be found, with the specific language combination required to interpret for the accused in a given case, then as I said, we recruit and train linguists with the requisite combination in simultaneous interpreting. Now, that process, we have said, takes a minimum of 6 months, bearing in mind there's also this requirement to have expeditious proceedings. And finally, one last thing, we also do work with linguists and trainee interpreters in the situation languages with regards to legal terminology, concepts of law, civil law, etc. One big aspect that we have to face at the court, and all interpreters face, is when it comes to quality. So what is quality? This is what is quality interpreting? This is a notion that's sometimes very different in different settings. In the court setting, participants generally want to see a sort of verbatim rendition of what's actually being said by the speaker. So just to give an example, when I was doing my conference interpreting courses in the past, the idea was also to try and make the speaker sound better, to remove redundancy, to remove repetition, to perhaps elevate the language, etc., to put some emotion in when the speaker was a bit flat or whatever. That's just not the case doing these proceedings. Repetition, for example, can denote hesitancy. The same words can mean something completely different, where hesitation is implied, or where the way you speak, your emphasis is different. And a simple example of that would be, for example, somebody's being questioned, "Where were you yesterday?" And the person could say, "I was in Paris." Now, that person might be saying, yesterday, I was in Paris, I was in Paris, for example. Now, if you render that as, "Where were you yesterday? I was in Paris," is that a faithful rendition of that person? Is that a faithful rendition of the demeanor? The words are the same, obviously, but the meaning is very different. And I use that example just to try and get people to see how exactly the same words are used in a different way. And what are we trying to do here? You have to remember that the judges, the defense, the prosecution, their job is not just to understand what's being said. They're not just. It's not just about, I don't know, what the price of barley is in X country or whatever. They are assessing the person as well. They're assessing demeanor. Is this person telling the truth? All these things are critical additional factors, which means that we have to be sort of ultra faithful to the original. I'm not saying verbatim interpreting exists, because there are certain things you just can't do verbatimly, but it is a lot closer to the source, I think, than traditional conference interpreting would be. So this is just to say, basically, so when it comes to the notion of quality in terms of what we provide for simultaneous interpreting, can be different to what you might see in a conference setting. And there's a nice quote about quality. Quality interpreting cannot be regarded as the sole responsibility of interpreters. All parties need to assume responsibility. And another quote: "The members of the court do not necessarily follow the oral submissions in the language in which they are made, but often listen to the simultaneous interpretation. This imposes certain constraints to which counsel should, in their own interests, be attentive in order to ensure that what they say is perfectly understood by the members of the court. Counsel must therefore regard the interpreters as essential partners in the presentation of their argument." That quote actually comes from the Court of Justice, but I like it. I like it because I want to say that we're not the only ones responsible for quality. It's about working together. It's about working together to create this environment, which is not a monolingual court with interpreting thrown at it. It is a fully multilingual institution where all parties and participants have a role to play. I just want to say something about accuracy as well, because this is a really important point. And here I'm coming to the issue of transcription. Now, what is transcription? When I when I interpret in the court, unlike other interpreting settings, I've done one event once where every single word I said was transcribed and put on a giant screen at the European Parliament. This was for speakers with disabilities who needed to be able to read it. And when somebody pointed it out to me, I have to say it was pretty terrifying, and I wish they hadn't done it. But it was basically all appearing. At the court, this happens. Actually, this isn't done through artificial intelligence or a computer software program or anything like that. It's done by real people, stenographers, court reporters, who literally type everything that's said in English and everything that's said in French. We don't have transcripts in the other languages, but what we do have are recordings, multi-channel recordings. So we have a software, and it's specifically legal software called For the Record. And what it does is it maintains up to 8 channels, separate language channels that record all court output. So there's a video, and you have every single language that was spoken. You also have, just a little aside here, you have 2 languages for the witness, not 2 languages, but 2 streams for the witnesses, because the witness, when their voice is broadcast outside the court, is often distorted, but we need to get the original voice, not the distorted voice, in order to interpret the witness. So we get the clear feed. So there are 2 channels just for that, for example. And so what we have on the one hand, we have full transcripts in French and English is what we say, and we have those recordings. Now, just to say about this transcript, so literally as I'm speaking now, imagine I was interpreting now, everything I would be saying would be appearing in this transcript. All the parties and participants would be able to look at it. And then if they perceive, each team has people who are looking at the linguistic aspects. And if they think something's wrong, they will get up and they will say, Your Honor, I think there's been a mistranslation here. There's an error of some kind. And sometimes they might be right. Sometimes they might not be right. But I think that is a dimension of our work, which a lot of interpreters just say, I wouldn't do that. I wouldn't want to be in that environment. And it is an element of additional stress. What I would say, though, is where the transcription is very well done, and where it's working really well, where you have it in front of you, it can act, for those who are a bit familiar with Gilles' theory on short-term memory, etc., and note-taking, it can act a bit as an additional note-taker. So it could be the case that if it's sufficiently fast and you don't get that number, you can glance at the transcript and you can find the number. It's kind of not really Murphy's Law, Sod's Law, to use that vulgar expression, but it's rather that sort of law that's often, if the court if we're struggling, then often the court reporters are struggling as well, and for the same reasons, because of sound, because of whatever. But I have to say, if you get used to working with it, you can use it as an additional tool to help you achieve a higher level of accuracy, and you can use it as this sort of additional short-term memory device or note-taking device, if you see it like that. So basically, just to go back to what I was saying earlier, so we have this fact that the court interpreter's output is transcribed, it's converted into a written form, if you like, taking on the allure of translation. This gives rise to end-user expectations of accuracy and reliability on a par with those for written translation. So despite the very different production methods, one being purely written and the others being spoken, the scrutiny that those transcripts are under are almost akin to a translation, not just a translation, but even a revised translation. And I rather like this quote about accuracy from the former registrar of the ICTY, I believe, with the surname Mackintosh, which might mean something to you in interpreting circles. Accuracy is central to the work of all interpreters. In a criminal trial, it is essential. The interpreter's words become evidence as they are recorded in transcripts that become the official trial record and are quoted in judgments. At the ICTY, the prosecution and defense are constantly scrutinizing the transcript in court, ready to challenge any aspect of the interpretation that they consider incorrect or prejudicial to their cause. And as much of the work of counsel requires reference to court translations, courtroom interpretation, etc., it is important to try and communicate the difference that there is between them. This is something that we've tried to do, such that when people say, oh, there's an interpreting error, etc., first of all, people have to understand the speed at which we're working. We're working, if you say per minute, 120 words per minute is a common rate. In fact, it was quoted as the sort of maximum speed for quality interpreting. After 10 minutes, you've done 1,200 words. 20 minutes, 2,400 words. That's already more than you would get from a translator in 8 hours under normal UN guidance. Now, all I'm saying here is that we cannot be expected to reproduce the same accuracy in 20 minutes as you could in 8 hours. Now, I know I'm preaching to the converted here, but it's important for those of you who are working in court situations. I'm presuming you that some of you are and do. I'm trying to also give you arguments to use with your clients to express these things as well. I've said the same thing a million times, but it might be useful to somebody else. That's why I'm saying it. But it is the case that sometimes we get things wrong. It's really important to say this. And when I've been training interpreters, I've never said, and actually I do the same when I'm coach rugby, I do exactly the same. I say, don't go in there thinking you will get everything right. Don't go in there thinking everything will be perfect. Go in there knowing something will go wrong. Go in there knowing something won't be okay. But go in there know that you've got the tools to put it right, that you're able to mend whatever goes wrong. That in rugby terms, if you do one bad pass, the next 10 are good. Do you know what I mean? So you can try and correct yourself on mic, and we do that. You can write notes for your booth partner. We do that too. Occasionally, we can interject to say, you know, if we've missed something, we can interject to say, Your Honor, could that be repeated, etc. This is another big difference I wanted to point out between court interpreting and conference interpreting is that we interject a lot more. I remember it was the one of the former staff at the European Court of Justice. He heard. I remember going to a talk. I think Christiana, you might have been there. But he came up with this great phrase that he thought sometimes court interpreters were more like interrupters than interpreters. But I think I would say we do have this facility to interject a bit more than you would in a classic conference setting. And this is really because accuracy is key. It's all about trying to get everything spot on. Now, what happens if we haven't managed to get everything spot on throughout and the transcript's gone out and this is what it says? We still have the opportunity to correct the transcript. And in fact, what is becoming a very big part of our work, and anybody who wants to work at the International Criminal Court, and I presume other tribunals which have transcripts that aren't translated should know, is that a huge part of our work now is correcting transcripts. So what will typically happen is you'll be sent sentences or phrases to review, and they'll say, we believe this is incorrect, you know, could you look at it? And most of the time it's things like the spelling of a name or a number or something like that that's come through, and these are important. But occasionally it might be a paragraph or whatever. And, you know, we you know, at the beginning, I think maybe we thought, oh, you know, it's hard for an interpreter to have like black and white put in front of them, you got this wrong, you know. But actually, no, they need that level of accuracy. And I think you have to accept that. They accept that interpreting isn't written translation. At the same time, there are only two ways to do it. Either A, you take the entire transcripts of every single day, which are 80 pages or something, and you get them all translated, which would take days and multiple people, but that wouldn't be expeditious. The fastest way to do it is to issue it, and then for those little paragraphs or sentences or whatever, which need markup, which need correcting, which need whatever, we sit down and we do that. And we've even developed specific software translation verification module, it's called, in which we can do those corrections. So I think that's all I really wanted to say about the transcripts. On the one hand, yes, it gives rise to very high expectations of accuracy. On the other hand, if used correctly, it can help you come up with a better level of accuracy. Now, I know I've spoken for quite long already, so I'm going to jump forward a bit and just say very quickly. I think one of the things I want to say is that it's very important, and I know I've referred to this earlier, is how to work with the judges and everybody working together. I think this is something that we have managed to achieve quite well at the International Criminal Court. I'd like to find just a little quote from a judge who was listening to an example of a correction when they say where the judge was basically quite pleased that the interpreter corrected it. I can't find it yet, but this is another example just to give you an example of correction. So question from this is the quote. Mr. Desailliers, so that was the name of the counsel. I think first and foremost, we have to pay tribute to the professionalism of the interpreters and that they would like to adhere to the oath under which they're doing their job. And why did that judge say that? That was because we said, we cannot do this. The sound quality isn't good enough. What the interpreter exactly said was, and I will find it, sorry, just looking here. The message from the interpreters: usually we do not interpret videos because of problems with sound and speed. On this occasion, we tried to do our best, but it's not possible to provide accurate interpretation under these conditions. And I think that's very important. We have to be honest and signal when things are just not working and when we can't deliver that quality. And for anybody who's worked in distance interpreting, you get very bad sound. What we've said at the ICC, what we developed, because you'd get really difficult situations where it'd taken ages to set up the video link. You were doing maybe a rape victim from Bunya or something like that. You don't want to say, oh, I'm sorry, the quality isn't good enough, we can't interpret. But at the same time, you can't make things up. If you can't hear it, you're just guessing, whatever, it's not good enough. So what we did in the end, we would say whatever we understood, and then we would punctuate it with inaudible. And I know some of you have heard me say this many times, but it really worked for us, because we weren't saying no, we weren't saying stop. We were saying we've got to the point where we're not prepared to make something up. We're not prepared to guess, but we will just say this. And then every time, it's never been a problem, ever. They've always reestablished the link and done their best to try and get it back. There's
Andrew,
so much
can I give you the 5-minute warning card? I think you're coming to a close, but you've got the 5 minutes warning card.
I really appreciate that. Okay, so I just wanted to, that was the point about how we do intervene a lot more than conference interpreters. And I generally think it's appreciated. Let's just take another one. So we do come in quite a bit. President Patasse asked us to kill all the children over the age of 2. So when I learnt his answer, I saw that my boys and myself were considered as dead. And when I went back home, I was completely sorrowful. I decided to get all my children and leave. I decided to stay. The interpreter corrects, kill all the boys over the age of 2 and not all the children over the age of 2. So gives you an idea of the sort of stuff we deal with as well. Moving swiftly on, I wanted to talk to you about best practices that you can also use basically in your dealings with your clients, in the courts, etc., in which you may be working. I think it's very important to have a good role with the judge, because the judges basically, they're able to intervene and they can intervene on your part. And ultimately, they're responsible for a fair trial. and they really do have the ability to speak to counsel, to speak to defense, speak to prosecution, obviously to be listened to. So it's very important to help them, because they want a fair trial, they want it to run smoothly, to help them understand as best they can what helps us. And here I'll come into just some recommendations that we made for counsel that I think have been very helpful. One is hearing preparation. So to provide interpreters with speaking notes or documents you rely on during the hearing. So basically, we've asked to get notes in advance, and this is something that they've been very helpful with. We also, of course, in terms of using audio equipment, we have recommendations. Another one is extemporaneous speech. So try and speak extemporaneously or from notes. Try and moderate your pace. Try and provide the interpreters with the text in advance, particularly if you're using quotes. A very important rule, and probably one of the most important rules, I would say, is what we've called the 5-second rule. I think I put 3 seconds in this because one of the judges was asking for 3, but generally it's 5. So what's this? Basically, you have a to and fro. You have question, answer, and what often happens when we are interpreting is that we also need to say the name of the well, not the name of the witness, but we need to say, for example, prosecution, witness, or the name of the counsel, etc. A lot of the time we just say a question, answer, because it's quicker. But that needs to be reflected in the transcript. Now, what I wanted to say is that the judges often request a 5-second break, a pause between asking the question and replying. And that makes it easier for us to say the names. It makes a huge difference to everything, because if you've got relay, etc., it just allows time for everything, and everything runs so much smoother. So I would say the 5-second rule in response to a question or in response to an answer by the witness is probably one of the most powerful things that we have available to us. And I write a list of recommendations, and finally, remember that interpreters are there to help you communicate as effectively as possible. So I'll just maybe read the conclusions of the paper I wrote, because I really want to get the message out there of how we can work best. So effective multilingual communication is at the heart of a fair trial, not only in international criminal proceedings, but in all multilingual courtroom environments. Courtroom practice at the International Criminal Court shows that a multilingual court is not simply a monolingual environment with simultaneous interpretation, but a multilingual judicial environment in which each and every party and participant to the proceedings is aware of their responsibility for ensuring effective multilingual communication with the presiding judge, the ultimate arbiter thereof. Despite the inherent limitations of simultaneous interpretation, where courtroom parties and participants work together, it is possible both to ensure accurate communication in the courtroom and to expeditiously produce a reliable written court record of interpreted oral proceedings. Although occasional linguistic errors can and do occur, effective review and correction strategies underpin the reliability of the final court record. And I do hope that these insights provided into the process of simultaneous interpretation and best practice at the International Criminal Court, and the recommendations that are made, are sufficient to help all of you as interpreters interact with counsel and other parties and participants in any proceedings you should find, to ensure that we can achieve the best possible result for the users of the court services. Thank you very much.
Thank you, Andrew. That was excellent, very informative, with lots of practical tips and a lot of insight. So I think that we're all the wiser for it. And I feel that if I consult my notes, I will feel better next time I enter a court setting, which is always very stressful, as we know, especially when we have excellent court reporters and you sometimes see your own speech transcribed. That's terrible. So let me now introduce Alfred. And it is a great pleasure indeed to welcome you, Alfred, here. He's going to give us a different perspective into the interpreting of the AIIC, which is that of rare languages, languages of lesser diffusion. Alfred was recruited by the AIIC in 2010, and he worked as a paraprofessional interpreter on the Bemba case, and in 2021 he was promoted to Associate Sango Interpreter and assists in training and end of training assessment of new recruits for his booth. I don't know if most of you were here when Andrew said what a wonderful relay he gives and what a valuable colleague he is. So I would like us all to warmly welcome him. And for those of you who don't speak French or understand French, we have excellent colleagues who are doing the interpretation, whom I'd like to thank also. Over to you, Alfred.
Thank you very much, and good evening to everyone. I'm Alfred. I'm from Central African Republic. And after I introduce myself, I would speak the beautiful language in French. Maintenant, je me permets de parler en français.
Now, I would like to switch to French. Can you hear me? Can you hear me? Hello? Yes, we can hear you. So you know me because I've been introduced by my colleague. I've been recruited in 2010 and I worked on the Bemba case. And after that, I had some previous experience as a translator and liaison interpreter. So, as I said, I was recruited in 2010, and with many other colleagues, I had a very intensive in-house training at the court. And that's when I started working as a paraprofessional interpreter in the Bemba case. And I kept working for the AIIC on a freelance basis, and my contract ended in 2013. I was rehired as a staff member in 2021, and today I am a translator and court interpreter for the Central African Republic situation, for which we have at least 3 cases. And now I would like to talk about our language because it is considered as a situation language at the court. And we have specific legal and judicial terminological challenges. So in the Central African Republic, there are 2 aspects. First, the Sango language and the French language. Both languages are considered as official languages of the country. But Sango is considered a national language. However, Sango is yet not fully standardized. And this despite the law number 84/031 from 1984. So this language is so not fully, as I said, standardized, but religious groups are trying to increase the alphabetization of that language for religious purposes. So if you're not familiar with the African Republic, Central African Republic situation, there is a variety of Sango, which is called French Sango, which is a mix of French and Sango, which is often used by the academic population, or a population with a higher level of education, at least. So it was quite a challenge for us because we had to create the legal and judicial terminology. And that's what we have been doing for the last month. We have built and enriched a lexicon And with the support of the terminology unit, we have developed the courtroom phraseology. Indeed, there is a specific phraseology, and we had to find the same equivalence in our language. In most cases, for the Central African Republic, there are new words or new terms that were not included in the charges. So this, of course, will trigger several issues. And this is an issue especially because new terms that we have developed are not implemented. So that means that we know that the language that we speak at the court is in a way too academic, and it's not always understood by everyone. And now to talk a bit more about court interpreting, I remember during the first day of the hearing, the accused said that he wanted interpretation into Sango. His counsel sent a note stating that his client could not understand the Sango we were speaking, because it was the Sango that we had developed and created and enriched. So that's why we had to come back to a more basic form of Sango, which is the French Sango. And when we did that, the accused was finally able to understand the terms that we were using. Also, it is worth mentioning that another challenge that we face when interpreting at the court is using the idiomatic wordings. For example, idioms, sayings, proverbs that are not always easy to transpose into the French language. Indeed, if we take into account the social cultural context, some terms will be difficult to translate. And of course, if you're interpreting simultaneously, you often will struggle. For example, during questioning, even for very simple questions, because Sango is a very concise language, we often have to explain or paraphrase. So we have to explain the question to the victim or the deponent or the witness. And now I would like to move to how we are seen as ICC officials by Central Africans. Because this is quite a tricky situation. Indeed, very few people know how the ICC work, and this despite many awareness-raising campaigns organized in the field. Indeed, many people think that we are collaborators because we work at the court. They don't know the role that we play at the court. And this could be the perception of the relatives of the defendants. They can ask us many questions like, why did you release Bemba? Or what did you arrest that person or not this person? But we are not the judges. We are just the interpreters, and that is something that is sometimes difficult to understand for other people, because they think that we are responsible for the ICC, and sometimes we are seen, as I said, as collaborators. And I would say that the only consolation we have comes from the victims, because victims, they see how significant our work is for them. Of course, the Central African Republic is a poor country where at least 60% of people do not speak French or are illiterate. So this is something we need to take into account, because thanks to us, victims are being understood and their voices are heard. And I would say this is our sole consolation. And before concluding, I would like to discuss something that is very important to me, is the post-traumatic syndrome. We are faced with documents that are quite violent, be it the statements that we have to interpret or the documents that we have to translate. These documents and these statements talk about crimes, and we also sometimes have to watch videos that are unbearable. And up until now, we've always managed to try and distance ourselves from these atrocities. But sometimes we wonder, how long are we going to be able to work without having this post-traumatic syndrome, because there is no psychological support at the moment. And I would like to mention one specific incident where we were faced with very difficult witness statements, for example. And in a way, we feel directly affected, because it could be someone that we know, it could be a relative, or that's how it is sometimes very difficult to detach ourselves from the situation. Also, we do not have enough staff interpreters. We do not have freelance interpreters working with us. And I would like also to pay tribute to one of our colleagues that unfortunately passed away less than 2 weeks ago. He was one of the key staff interpreters when we start in 2010. And I think that it will be very difficult to keep working without him. Thank you. Thank you for your attention. And if you have questions, I am very happy to reply. Thank you very much.
Thank you so much, Alfred. That was very interesting indeed. I would just like to say that Alfred had a problem with his camera, and we managed to get the second screen up. So he's spoken with quite a bit of difficulty today. So there was a few setbacks, let's say. But you did an amazing job, Alfred. That was so interesting indeed. And we are going to go on to a Q&A questions. I see there's some in the chat. You can also take the floor and speak if you want to ask. You can ask in French or in English, obviously. And I'll start by certain questions that were put in the chat during Andrew's speech. I read Marguerite. There's Pinto's question. Is the message spoken live or in a chat? I think it has to do with when you speak to the judge and make a request, if that request is made over the microphone or in another way. And there's another question by Miranda Papadopoulou about the breaks in the process. Are they predetermined, or can you ask for them when you get exhausted?
Okay, this very good questions. There are two ways of contacting the presiding judge. Normally, if we have time, it could be that there's something which is going to be a problem, or the sound's generally not good or something. We could write a little email to the court officer, and then the court officer would then turn around, speak to the presiding judge. If you've got time, that's the way we do it. Otherwise, for messages, for example, like the interpreter didn't hear the last part of the sentence, or that sort of thing, we literally have to say it live on mic, so it's heard by all parties and participants, and it's broadcast all over the world, of course, at the same time. But then that way the message does go to the presiding judge. And the most effective way what we found to do is to deal with these things is basically to say if there's something we know we haven't got, and then to ask if the presiding judge could ask if the witness can repeat it. And I think that generally goes pretty well. In terms of the breaks, I think a lot of people will be like quite surprised when they hear about our hours and breaks and things. I think they think we're extremely lucky. We work generally 3 times 1.5 hours in the courtroom, so 4.5 hours a day. It's also possible to do 2 hours in the morning and 2 hours in the afternoon. We have the standard AIIC 1.5 hours for lunch, and we have a 30-minute break. If we have 2 1.5-hour sessions, we have a 30-minute break between them. So a standard day for us would be 9:30 to 11, 11:30 to 1, and 2:30 to 4. Now, we rotate in slightly different ways in the teams. If it's a monodirectional booth, we generally have 3 in the booth who we have generally 3 in the booth working into English, 3 in the booth working to French, which means it can be half-hour break, half-hour lunch, half-hour finish. Or alternatively, we can do it in 2s, and then maybe you have half a day to work on transcript correction or something like that. That's also something that occurs. It's different in the bilingual booths. So the bilingual booths, they tend to work in a booth of 4. So 2 in one direction, 2 in the other, which yeah, it seems a bit unfair because in a sense they're probably interpreting on mic more time than us. Yeah, it's also a case of being able to find the number of interpreters as well. But that's basically what I can say with regard to the breaks and yeah, with regards to the messages. Just one thing, because I know there are often rules regarding how many sessions people do per week. We don't really have that, so we have those, as I said, number of hours. So it's kind of assumed that we do those 5 days a week. But to be honest, we often get 1 day or maybe 2 days in a week here and there where the witness, for example, might finish early or whatever, and then we're working on translation instead. So it's currently, it depends on the period, because we've also, as Alfred can tell you, had days where we've just worked for months on end without a single day out of the booth. But as it is at the moment, we sort of alternate mainly in the booth, but occasionally work on transcript correction on other days.
Thank you. I think that also more or less covers the question that existed on manning strength. So we have a question which I will direct to Alfred, and that is from Apollonia Otam. Thank you again, Andrew and Alfred. I'm worried because it seems that not a lot is done about mental health. What can be done? I mean, Alfred, you broached on this during your presentation, and it sounds like you get to experience very harrowing things through the interpretation, very difficult situations that the victims have gone through and which are conveyed to you also. Is there anything you believe that could be done that is not done? And after Alfred has spoken, if Andrew wants to add anything, of course, you may.
Très bien. Vraiment, merci
Thanks.
pour
Many thanks for the question. Well, it's true, when we worked in the Bemba case, it was based on pillaging and rape. There was a lot of that involved. And then we experienced, obviously, difficulty, given the horrible nature of the crimes. So what was set up was a system with a psychologist. I think the name was mentioned. And this enabled us to discuss things and talk them through at the end of each hearing. We were able to talk things out to relieve the pressure. But sadly, recently, there are budgetary constraints which mean that we don't have easy access to this sort of psychological follow-up anymore. it's difficult to talk about such things because they're confidential, of course. You can talk, maybe you can't talk about it to your family, you can only talk about it to your colleagues. That's how things work out. We do our very best with the resources we have, but we're not quite sure what's going to happen in the 2 or 3 years to come. Are we going to end up falling into some terrible psychological state because of what we've heard? We don't really know what the future holds for us. So that's the answer I can give to the question which was posed. Thank you.
If I could add to what Alfred said, I think this is, I mean, those who've heard me speak at AIIC meetings before know I find it really difficult to talk about this issue because I get like little flashbacks talking and you're there with a person and it's very emotional. Bemba was the worst. Bemba, Alfred will support me. It was the absolute worst trial, the worst atrocities, the most horrific things. It was terrible. It really was terrible. We did these group de parole afterwards, where we talked about the things, and it was good to come together with the colleagues, I think, and talk about them. My biggest problem was because we were so busy at the time. We were in the court every day, 5 days a week, long days. It was after our work, so after the day in the court, and then I kind of. For me, I like to do activities where my mind is literally forced to think of something else. So I literally, a bit like meditation, something. But for me, when I'm coaching rugby, I literally step onto the pitch with the kids, and then I'm kind of transported to a different place, and I'm doing my thing, and I'm running around, and then afterwards I finish, and I suddenly remember, oh yeah. This is what I was doing before, or when I'm doing, like I do a lot of theatre, some amateur theatre, and I find that the focus on the lines, what are my lines, what do I have to say to it, it all takes you to another place. It all knocks you off, if you like that. Just imagine your brain was operating at a certain frequency. It kind of knocks you off that frequency and takes you somewhere else. And I would say anything that takes you somewhere else is very good. Just one of the worst things for me was actually after Bemba, when Alfred and his colleagues were sent away because suddenly there was no need for them anymore, and they found themselves in quite desperate situation. And one of them even had his house completely looted and pillaged and ended up in an IDP camp himself. So to have the interpreter who used to sit next to you and provide you with your relay, living in an IDP camp and having his house pillaged and everything else with the crimes that you'd heard of, and his family were there as well. I think that was hard to cope with, obviously for them more than me. I wasn't sitting there, but I did raise the appeal with AIIC, who came up with a fund, a solidarity fund, which helped repay for some of the reconstruction of the house, etc. So there are things you can do. There are things, positive things you can do. And just one last thing, I like to be involved in anything to do with teaching, because seeing something get better and grow is positive.
That's a positive note to end on. Thank you. George, would you like to say something?
Yes, thank you, Katerina. I can only endorse what you've said, Alfred and Andrew. This problem of psychological support is a problem which is nothing new. Our colleagues at the Nuremberg trials experienced exactly the same, and I'm very sad to say that in the meantime, very, very little has been done to remedy the situation. I know from my own experience, and Christian can endorse me on this, we have witnessed colleagues who have come out of the booth at criminal tribunals, for example, the International Criminal Tribunal for Rwanda, completely mentally wrecks because of what they've experienced in the courtroom, and they've had to process this afterwards, and they're left more or less to their own devices. I can speak from my experience at the ICTY. It was very similar there. I really don't think enough is being done. Maybe this is something that AIIC could address with a bit more energy and a bit more elan to discuss this with our partners at international criminal tribunals in particular, to ensure that some sort of psychological support system is up and running, not only for witnesses. This is fairly common, and it has been practiced in many international tribunals, but it's in particular for interpreters. Thank you.
All right, you are, George. Thank you for that. Christiane?
Well, we had the same experience, George and me, but I also experienced interpreting under such circumstances. And I can tell you that it is, I cannot no longer hear that we should cope and do something else to relax, because it is far more difficult, and it makes you really ill. At the beginning, you think I cope, and during the interpretation, you stand next to yourself, you know, and you interpret, you function in a perfect way, and then you come home, and then the first night maybe you cannot sleep, and then you sleep many nights after another, and then suddenly you realize that you have a big shock, and you have to consult a doctor. And I am shocked, because after our experience at the Rwanda Tribunal with George, we made such a recommendation because people had no help at all. And we had heard that at the Tribunal for Yugoslavia, they had help at least. And I would have expected that the colleagues at the International Criminal Court would do something and simply not accept it, because now you function, but in 2 years of time, and Alfred is completely right, you never know what is going to happen. And I can tell you, I've met colleagues who have worked with the Rwandan Tribunal, and they are now ruins. They are really not functioning in their life. And I met them 10 years ago or 20 years ago, and now when I see them, I'm terrified. And I think this is something either AIIC or who, I don't know, maybe there should be a sort of trade union or whatever at the tribunal, but you have to do something about it. It's no fun, and not playing rugby will not help. And I'm very worried about you, Andrew.
Well, that encourages
I
to
did actually have a
Mhm.
burnout already on that subject. I did have a burnout, so I was ill myself. So yeah, I mean, the only one thing I would say about the court is that they do provide a budget for a psychologist who you can go and see, so you can, on your own initiative, go and find somebody and talk to them. But I do think having, you know, finding people with like-minded experiences would be helpful. I think more of a, you know, a cross-cutting thing, like we said, that maybe involving different courts, different people, would be more helpful, because anything I can do with for example, the medical insurance, it's one-to-one with a psychologist, and I think that sort of thing can help, but it's just not the same as speaking to other people with very similar experiences, because I think there just aren't that many people who have such a similar experience, if you know what I mean.
Well, that's definitely food for thought in AIIC, and we have to see how we can get about that. That's very interesting. So there's various questions that have to do with the legal interpretation training and tests, and how people can become recruited. Now, if you want Andrew to just touch upon that very lightly with respect to what happens in the ICC, so that people can have in broad strokes what's happening, because we are going to be talking about interpreting, or rather teaching legal interpretation in other webinars. So that is a point that might best be left for then.
Okay, yeah, just very briefly. So let's start with recruitment of already trained recruitment of conference interpreters to work at the ICC. It's quite simple that a vacancy announcement is put out that they're looking for interpreters with X languages. So obviously in languages where these interpreters already exist, for example, like Arabic, English, French, this sort of thing. And then people come and do the interpreting test, the ICC interpreting test, which I think is pretty hard, but you know it's doable at the same time. The idea is really to try and get the best out of people, see what they can do, and then yeah, the recruitment lists are drawn up of the people who've passed, and you have a list, first candidate, second, etc. And then that list is valid for a certain period of time. That's the case with the sort of more standard languages where you have existing freelance interpreters, etc., who are already working as conference interpreters. It's obviously very different when it comes to recruiting interpreters for situation languages where there are no existing interpreters in that language in the whole world. In which case they have to go through, well, how do you find them in the first place? I'm not the best person to ask, actually, because that's not part of my job, but we do have a situation language unit who they're the ones who sort of scout around looking, for example, maybe at displaced communities, this sort of thing, to try and find people with a requisite language combinations. Security is a huge issue. So they'll often find good linguists, but for one reason or another, they don't pass security vetting. And it's often that people with access to the type of education that would have been necessary to do the job might then have connections to the government or whatever, which makes things difficult. So it can be extremely complicated. I think where they've managed to have a certain degree of success is finding sort of people expatriated from that country living somewhere else with the vehicular languages. So generally, for example, if it's somebody from, well, people with Sudan with Zagawa, it was Zagawa Arabic, the combination. You didn't have sort of Zagawa English. So that was then Zagawa Arabic, English, or French. The interpreting was done with Lingala, with Sango, with Congolese Swahili. That was all in a combination with French. And then, of course, you have a Choli, for example, from Uganda. That was done in combination with English. So that was all of those involved the sort of 6-month testing, training program. And the training in another book, I could go on about that another time, but that's all for now.
We are actually going to hold a webinar about training, especially in the languages of lesser diffusion, where we'll have the opportunity to hear Christian Driesen and other colleagues about that. So we'll look forward very much to the next webinar. Now, there's a question about how do you translate legal terms into Sango? I don't know, Alfred, do you want to take that question?
Oui, c'est une très bonne.
Certainly, it's an excellent question. Well, we don't have any basis to judge when we recruit. It's hard to ask for that, but even if people have a legal background or a diploma in law, for example, it's still not easy because the legal system in the ICC is specific to the ICC. So even those who have studied law at some stage, they have to buckle down to studying the terminology at the ICC. I never had to interpret a hearing before, but I was able to do so thanks to the training I received and the terminology and glossaries which had been put together. And then we had a lexicon also, which I was able to use, either a glossary or lexicon. And then on that basis, we work and we can work. We use this as inspiration, and it's the basis of all we do. And of course, we update it constantly because there are new terms which come up depending on the hearing and the case. And this enables us to feed into the glossary and to enrich it and make it more extensive. That's more or less how things function. Even if someone hasn't got a background legally speaking or judicial matters, they can learn and follow the training which is provided based on the terminology which is put together. Thank you.
Thank you. That's very interesting. And there's a second question that relates to the use of Sango and the situational languages. And that is, what happens if one of your colleagues falls ill? If somebody's sick and they cannot interpret that day, do you have a sufficient number of colleagues that would be able to help you?
Bon, là, devant la...
Well, there, given there's an increasing number of hearings now and cases being dealt with by the court, we have 4 colleagues who've just been recruited and trained. Obviously, they recently passed our tests, thanks to Ali Bougou, the Benedictis, who helped us, and other colleagues also provided support, and this enabled us to end up with 8 interpreters for 3 cases. So if somebody falls ill, as happened in fact last week, because we had 2 trials going on at the same time, which required Sango interpretation, so we had to work in teams of 3 for an entire day. We had to enable a turnover working till 4:30 p.m. With a team of 3. That sadly can happen because there are no freelance interpreters available, and we just lost a colleague who was very experienced, in fact. Thank you.
Thank you. Very interesting indeed. I think that brings us to the end of the questions in the chat, unless I've missed something. And I'd like to ask George and Christian to see if anything has been missed. And I don't see any more hands raised. So I'll just give Christian a minute to peruse.
Well, the most important things when we come to this point is, first of all, to thank all the participants for their patience. We have still so many, more than 100 participants, very patient and very interested. And I would say to our speakers, it is wonderful what you have achieved, because people were really glued to your presentation, which is great. And it's for us at the committee, we are very grateful to you, because you made a very big success for our event. And we thank the interpreters. It is great that they were so dedicated, that they helped us and supported us so that we could have at least bilingual presentation, which is important, because it is our profession to show that we interpret, that there can be interpreted, and that we don't need to speak English all the time, because our profession would disappear if we don't stick to interpretation and speak several languages. So I thank you all. I thank you, the speakers, and big thanks to the interpreters, and also a big thank to Katerina and to our Greek colleague, the Greek Association, Maria, and I hope that we will continue our cooperation. And thank you. And Katerina, I don't know how to thank you for the big work you have done, and all the responsibilities, and fighting and writing mail back and forth. I think we exchanged at least 70 emails about these meetings, and it was all Katerina working and working on all details. She took care of everything. And I could really relax, you know. She just asked me, but it was great what she has done. And a big applause to Katerina and to all our speakers and interpreters. Thank you all.
So I just want to say one final thing before we close. I think it's important to say the names of the interpreters again for those who didn't hear it the first time. Camille Collard and Chris Guichot de Fortis, thank you so much for volunteering. I know it's the toughest job ever to do it before colleagues, so I think that you are amazing. Thank you so much. And for those of you who want to attend other conferences that we organise, please keep your eye on the AIIC web page for legal interpreting, AIIC event web page, and the LinkedIn page for the Legal Interpreting Committee. And once you hear about it, please spread the word. Thank you very much, Andrew. Thank you very much, Alfred. You were amazing speakers. I don't know how you did it. Well done.
Merci.